Okay, so Alison, I'll just say a few words about myself, and then if you'd say a few words about your work, I'll be happy to click to the slides here for you. My law practice specializes in working with families with kids with disabilities and special needs. And of course, one core piece of that is Henson Trusts after the parents are gone. But the interesting focus for this particular session is looking at families whose children, young adult children, have psychological or mental health issues, which is your specialty. Mm-hmm. From my standpoint, people often ask about, excuse me, about powers of attorney and legal guardianship. And of course, a person should have their child who's 18 or older sign powers of attorney, property and personal care, especially personal. Now, of course, they can always be revoked. That's an issue. Often the child's paranoid. Why should I sign this? What do you want me to do with this? What are you going to do with this? Are you going to commit me? You know, it's very common. So, of course, you can try to speak to the mental agitation and fear and paranoia and all those things. But in practice, what we try to do is we try to get it signed. We've had situations where we've had to basically bribe the child. I remember one time years ago, we used an iPhone. You know, so you have to speak to whatever it is that motivates the child who's mentally ill. And aside from the mental illness, they may just be a self-centered child. You know, they're not stupid. They may be extremely street smart. And yes, by the way, they have a bipolar disorder, right? People with disabilities are just like everybody else. Most of them are nice, some are not. And a lot of them can be easily, learn easily that being manipulative, pushing their parents' buttons, you know, they're just like everybody else. But sometimes they get away with more because the parents feel sorry for them. Oh, my poor child, you know, that kind of thing. So it's very interesting. And one way we get the powers of attorney signed is in the context of the mom and dad doing their own wills and doing their own powers of attorney. And we appeal to the child's, the young adult's self-respect. They're adults, their parents are adults, everybody has a power of attorney. What happens if you're sick or hit by a bus? And we find that in the context of the parents doing their work, quite often it's easier for the parents to have the child sign their powers of attorney as well. We'll come briefly to a slide later. There was a woman who contacted me. She's a capacity assessor that we've worked with. And she said, Ken, what about ULYSSES clauses? And I thought, oh, yeah, right. I hadn't thought about ULYSSES clauses for a couple of decades, but we'll get to that. And it's a kind of a power of attorney for personal care that, with certain steps involved in capacity assessments, is not revocable in certain ways and is enforceable so that a person has a prior agreement that can be changed to have compellable treatment. So it's fascinating, but it's a bit of a rigmarole. But what it would be is an alternative to the inevitable question of, my son's really not capable. Should I have a should I have a legal guardianship application so that I'm his legal guardian? And that's a common discussion. But a power of attorney with personal care with the ULYSSES clause is an interesting interesting alternative to discuss. We also deal with our DSPs because, of course, the child with mental health issues may well be approved for the disability tax credit. They, for example, quite often can't set and keep goals, and so they qualify for the disability tax credit, and the credit is transferred to the parents. We often backdate these credits up to the 10-year maximum period, and we capture about $16,000 for the parent, who's the tax-paying party. But it also allows the child to have a registered disability savings plan. And a short story, if the parents contribute $1,500 a year, the government puts in $4,500 a year for 20 years, which is pretty sweet. But then, of course, the client turns to me and says, yes, but as soon as he knows there's money in it, he'll go and try to take it out. And of course, the RDSP belongs to the child. He may not be the account holder. The parents can be the account holders if the child's not competent, or if they have a power of attorney or legal guardianship. Legal guardianship would block the child trying to take money out, but the power of attorney wouldn't. So we have to, in practice, either do this very discreetly, keep it private, even though it is the child's RDSP. There are ways to keep it very private, very discreet, or to let the child know, keep them involved in the process, use it as a positive thing, a therapeutic step. But then when they go ahead and try to get money back out, which means that the grants and bonds would be lost, then of course we would have the financial advisor that's involved in this process notify us and the parents, and we would run interference until the child says, oh, okay, I guess I won't do that. But it is an issue, it's a problem, and sometimes you just can't do it. You can't, which is very unfortunate because everybody else gets to put in 30,000 and get 90,000, but not this boy, because he's mentally ill, which is very unfortunate. And then as we get to the end, we'll talk about the wills, Henson Trusts, funding trusts, who would want to be a trustee for this child who is eccentric at the best. So you can see that there's issues around this, of course, that are of concern. So that's my intro. Alison, would you like to give an intro about the kind of day-to-day work that you do?
Sure. So Dr. Baruch and I work at Michael Garron Hospital. It's part of the Toronto East Health Network. And just to put it in a context, it's a community teaching hospital located in the East End of Toronto. And we service a diverse community, about 80,000 people per year in the emergency department. And mental health is a priority in terms of the hospital's priorities. If we can have the next slide. Yep. Services are provided by an interdisciplinary team. We provide services to children, adults, and seniors, inpatients, outpatients, and a community outreach service. So we're quite comprehensive. We have 40 adult inpatient beds for mental illness, children and adolescent beds for mental illness, and we see 1,000 outpatient visits annually.
That's a lot.
Yeah, we are a very busy mental health facility. What I run is the Family Support Program, and we provide psychoeducational programs for families for the last 30 years. Our focus is to assist families in caring for their loved ones who have mental illness, often very challenging and very demanding for families, and we try to help and support them in whichever way we can. Part of it's done through staff support, but also families providing support to each other with our facilitation. what we've heard over the years, that the challenges that families face are difficulty navigating the healthcare system. And I know it's very hard, and that's where I would encourage you, if you're a family member who's caring for a loved one, to try to connect with a family support program in your community who can help guide you through the healthcare system. Advocating for loved ones is often very complicated too, because of the conflict between mental health and privacy legislation. Clients, we call them clients or patients, do have, through the privacy legislation, are able to prevent family members or anybody else that they choose from accessing their records or from talking to their healthcare team. And this can often be very difficult for families, particularly when the family member is discharged from the hospital back to their family care. What we encourage is to try as best as possible to encourage your family member to give permission so that you can be included in the treatment planning process. That's the ideal situation, is if you're part of the treatment planning and then can work with the family member, but they might not have insight into their illness and they might not be willing to allow family members to participate in the treatment planning. What is important though, if you have concerns about a family member and their health status, even though the doctor might be prevented from sharing their concerns and their treatment plans with you, you are able to call and contact or email the person responsible for that individual's care and describe whatever concerns you have to them. Now, one of the things that I don't know if Dr. Baruch will be able to talk and connect with our webinar today, but if so, I'm sure she'll support the fact that she would encourage the families of her patients to call in with any concerns that they might have, but bear in mind that the physician will, in all likelihood, describe that concern to their patient when they see them. So for example, we have a situation today where a family member called in about her concerns about her son, who had posted things on social media that were very concerning about his feeling at harm to himself, that he was talking about being suicidal. And so we encouraged her to call the doctor who is treating him so that he can, and hopefully Dr. Baruch will be able to call in and describe more about the involuntary treatment process. But to either, we encourage her to try to get him to a hospital, because if he was suicidal, he needs to be in a safe place. If not, then to get the doctor that's responsible for his care to invoke involuntary assessments. The other thing that we notice with our families is their, sorry, if we can go back to the previous one.
Yeah.
Is self-care. That families invest all their resources in their loved ones, their financial resources, their emotional resources, their time, and often neglecting themselves in the process. And we always use the image of, you know, when you go on an airplane and they give the spiel about if the mask comes down, where do they tell you to put the mask on first? They tell you to put it on yourself first, because you can't keep care of yourself. And we try families is, we know how much you love and care for your loved one, but it's also really important to address your own needs and take care of yourself so that you can be available and in the best possible care for yourself in terms of helping your loved ones. Is Dr. Baruch able to call in so she can address involuntary admissions?
Karen, do you have Dr. Baruch?
I don't have her on the participant side. I have, and I can't see who's the 5 call-in listeners.
All right, so I'll go ahead and address. So we talked about if somebody is a risk to themselves and they might need to be involuntarily admitted to a hospital. There are 3 ways in which you can do that. If somebody's a danger to themselves or a danger to somebody else, or they're not able to care for themselves, and you'll see further on in the presentation is a copy of the forms that can be completed. One of them is through a physician, and it doesn't have to be a psychiatrist, any physician who's seen that person in the last 7 days and deems them to be at risk to themselves, risk to somebody else, or not able to take care of themselves, could fill in a form which would allow the police to take that person to a hospital where they could be assessed. And then they have to be assessed by a different physician to determine whether they need to be kept in the hospital involuntarily. The second one is through the justice of the peace, and that's the way in which a person gets involuntary admitted is if a family member or a worker, for example, somebody who's concerned about the individual in terms of their safety risk or the risk to somebody else, or again, the inability to take care of themselves, then they can also, a justice of the peace can invoke a form which would allow the police to take the person to a health facility where they could be assessed and determine whether or not they need to be held in that institution by a physician who sees them there. What's important with that is the justice of the peace is not a mental health professional. So they're making decisions based on the information you give them. So if you feel that the person needs to be involuntarily admitted and you go in front of a justice of the peace, you need to make sure that you have as much information as possible so that they can make an adequate decision about their welfare.
Can I jump in for a sec?
Sure.
For the participants, you'll see on your screen there's a question and answer icon. You're quite welcome to ask questions. And if you want to be anonymous, there is a box for that. So feel free to ask questions and we'll be happy to answer them.
Okay, and then when the Form 3 is when they reassessed in the hospital and it's determined that they should be involuntarily admitted. That's what, so it's a different physician than the original physician who filled in the Form 1 who does that. Any questions related to any of that?
Well, I have a question. How does a parent go about getting these forms issued? Like they can see the child, they see the child needs care. How do they get these forms in place?
So one way would be to get a physician to assess the person, and it's up to the physician to make a determination whether they need to be involuntarily admitted. And it doesn't have to be a psychiatrist. And it doesn't have to be at that moment. So for example, we had somebody who saw the physician 4 days ago. When they saw the physician, they were pretty stable, but still showing signs of their mental illness. But then 2 days later, actually, the family had called us and said that the person had deteriorated and were now at greater risk of actually harming themselves. So our suggestion was to call that original physician who'd seen them because they have to have seen them in the last 7 days, and they could then issue a Form 1. So that's one way, is through a physician. The other way would be through going to the Justice of the Peace, where they can issue Form 3.
Yeah,
is the police officer determines the person is at risk, they can then, under the Mental Health Act, take them to a hospital.
Yeah, it's a problem. You know, the parents have to wind up being many experts themselves, of course.
Yeah, right. And that's where it's important to connect with, if there's a family support program in the community, who can help guide you and be a support to you through that process. So there was an addition made to the Mental Health Act, which said, sorry, I'm just trying to find it. The print is very, very small here. So there's also the past-present test. And I don't want to get too technical, but there are other times that a similar kind of form can be issued. And it says here, box A, I have reasonable cause to believe that the person has threatened or is threatening to cause bodily harm to himself or herself, has attempted or is attempting to cause bodily harm to him or herself, has behaved or behaving violently towards another person, has caused or causing another person to fear bodily harm from him or her, and has shown or showing a lack of competence to care for him or herself. And the future test, which is at the bottom of that, I am of the opinion that the person is apparently suffering from mental disorder of a nature or quality that will likely result in serious bodily harm to him or herself, or seriously bodily harm to another person, or seriously physical impairment of him or herself. And then if you can go to the next slide. If you can go to the next slide.
Oh, sure. Sorry, I thought you said line.
Sorry. Then box B. And has shown, sorry, so it's the first box, and then it also has shown clinical improvement as a result of treatment. And I'm of the opinion that the person is incapable, with the meaning of the Healthcare Consent Act, of consenting to treatment. So, and then fourthly, is apparently suffering from the same mental disorder as the one for which he had previously received treatment, or from a mental disorder that is similar to the previous one. So if the person's previously known to have benefited from treatment, that in conjunction with the first part can be a requirement for the physician to issue the form. Any questions related to any of that?
I'd like to ask Karen, my assistant, a question. Karen, we're not getting any questions and answers here. I've just clicked on question, Q&A.
Yeah, I only have 2, and I answered 3 of them, but it had to do with they couldn't hear the sound, and somebody was just wondering when it was going to start.
So when you click on the question and answer, where's the box? Where do you enter your question?
Well, I'm seeing what you're seeing, Ken, so I'm not really sure. Just give me 1 second.
We have a question, Alison. David Pelly says, where do we get these forms?
So you would get, if you're going to the Justice of the Peace would have the forms. And the physicians should have the forms, whether they're in a hospital or in their practice.
And how do you do this?
You can download it from the internet as well.
How do you do this in practice?
So in practice, what we do is we send, if we're concerned about somebody and we know that they have a physician who knows them and who could fill in a form to have them involuntarily admitted, we'd either get the family to take that person to the physician, or if the physician's seen that person in the last 7 days, then they can fill in a form as well. But I should say, I have a lawyer who works with KMH and is there to protect clients, to make sure that their privacy and their health is respected. And she is very clear in terms of when she takes, if a client wants to, I should mention that if a client wants to contest in involuntary assessment, involuntary admission, we are obliged to a rights advisor and go to consent and capacity board where they get it. And that's where a lawyer would get involved, and we'd have to help the client access a lawyer to protect their interests. So for example, so this lawyer will say, one of the reasons she can sometimes get a client, get the involuntary admission nullified is if the form was issued and it's not 7 days times 24 hours. So if it's 1 or 2 minutes even the form would be invalid. So we have to, stick very carefully to that requirement.
Are there any organizations like, for example, Schizophrenia Society that would help people with these things? Like having a stack of forms and helping to fill them out?
No, so an individual can fill them out. Only a physician can fill out the Form 1 or a justice of the peace.
Right.
So a family member can fill in a form. They can go before the justice of the peace and advocate why they feel that the person needs to be taken to a hospital to be for their own protection.
Yeah.
But the Schizophrenia Society, for example, are very good at helping people, guiding people as to what their options are. Absolutely. And I would encourage people to contact either Mood Disorder Association or the Schizophrenia Society, or a social worker in the hospital, or if there's a family support program in the community. Absolutely, that they can get guidance that way. Yeah.
I mean, we're all talking around the issue here. We all know how difficult this is in practice. The families all seek assistance and run up against brick walls. And I mean, even if we got a copy of these, maybe I'll post it on my website. Maybe I'll get the forms, post them on my website. People can print them. But even then, what do? Do you take it to the child's doctor who hasn't seen the kid for 6 months?
And they can't.
Right. Yeah. Right. Yeah. They can't do it. Right. What do? I mean,
so in those situations, we'd suggest if you feel that the person is at imminent risk, absolutely go to the justice of the peace, and you've got to explain very carefully why you feel, because remember, their rights are being taken away. They're being put into an institution against their will.
That's right.
So you have to have very clear indications, and they have to feel that that it's justified.
That's right. They're being given the right to be ill. Yeah.
Yeah. Absolutely.
Interesting, eh?
Yeah. So if we can go to the next slide. So these are just all the different forums. And if we can go to the next one and a couple after that.
Sure.
So rights advice. At any point in time, if somebody's held involuntarily, we have the responsibility to provide them rights advice and to help them to find a lawyer to represent them at the Consent and Capacity Board. And at that board, the board can determine whether the person is in a place where they should be held in the hospital, for example, or whether they have the freedom to be discharged. The Consent and Capacity Board is usually made up of a lawyer, a physician, usually a psychiatrist, and I think then a community member as well. In terms of community treatment orders, Dr. Baruch was going to address this directly. I'm not sure, perhaps, I don't know if at the end of the webinar, if we can add something maybe in writing about community treatment orders, because that's definitely not my area of expertise.
Sure. My community treatment orders are excellent. They're really an excellent tool. We have a question. Could you say a few more words about the Form 2?
Form 2, the form that the Justice of the Peace fills in? Sure. So I use 211 a lot. If you don't know where your local Justice of the Peace is, you can call them and ask where would be the local Justice of the Peace. And like I say, they're from the judicial system, they're not from the mental health system. So they have the authority to to fill in a form which will allow the police to take the person to a facility like a hospital. What's really important is that they have to be of the belief, given the information that you provide, that the person is a danger to themselves or somebody else, and that they can be taken to a mental health facility or a general hospital with an emergency department, where they would have to be reassessed again. So what we suggest is take as much information as possible, the person's previous history, their symptoms, describe exactly what they've said, what they've done, in as best way as possible, what your concerns are, why are you taking them, why do you feel that they need to be in a safe place so that they don't act on some of the threats that they've been making, or some of the, if they're incapable of taking care of themselves, and they need to be in a protected place.
Yeah.
So, and also take as many people as possible that would be able to talk to that. So family members, if we've had neighbors who've been concerned and taken and gone to the Justice of the Peace because they've been concerned about somebody who's been acting in an unsafe way.
Yeah, some of my clients have gotten lucky, and their child has done something, some bad behavior, trashing an ATM machine or threatening someone, or this kind of thing. And so then this, of course, brings the police into it and starts them into the system. They start to get a record. The doctors know about them. Of course, it's a merry-go-round, of course, because then they're taken into care and treated to some extent, and then released. And I've had situations where years go by. The child continues to be ill. They're taken into care repeatedly, drop down of care, return home, and you get to points where they're a threat to the parent, they're a threat to the stepfather. Parent can't do anything, right? They can't fix it. And I've had situations where you have to basically have the child taken into care. They're going to be released because they have been a dozen times. And you have to board up your home, change the locks, change the phone, move, leave, sell the house, because there is nothing coming from the situation. If you're in Red Lake, there's just nothing. I have a client on an island out in BC, and same thing. She built a home for the child on her property with her home, but then things deteriorated to the extent that basically she had to sell her home. And she keeps in touch with the child, and she can transfer money like $50 or $100 a week. Of course, you can't transfer more than that, because of course you'll spend it as soon as it comes in. It's all gone, right? But she can contact him. He doesn't have her cell phone, but it sometimes, of course, deteriorates to a very awkward situation.
I know it can be really, really hard on families, because you love your loved one.
Yeah.
And if they weren't ill, they're often the most loving, caring
Absolutely.
individuals.
When they're not sick.
And that's where it's really important to try to get them the appropriate help. And we try to encourage families to be as involved as possible and use the supports either within the community or within the treatment facility, so that care and concern can be communicated and need. But
you have a tough job.
I know it can be really, really hard.
Yeah,
Hear it all the time.
You have a tough job.
Well, we know how much the families love each other and how much they want their loved one to be well. And sometimes it's a mourning process that they go through in terms of recognizing that their loved one has an illness, and it can often be a struggle. But using supports in the community to help not just their loved one but themselves is really, really important.
It is, yeah. Do you want me to talk about powers of attorney for personal care?
Absolutely, yeah.
So, while a person is alive and competent, all adults over a certain age can sign a power of attorney for personal care. And what it does is it takes nothing away from them, and it can be revoked, but it grants to one or more others the ability to help them, and it gives them the right to have access to information in the healthcare system that the other otherwise wouldn't have. It's a very powerful tool. If the child won't sign it, which is not unusual, then if it's just personal care, and if the child is not competent, right, they've been found, maybe not found in the sense that their lack of competence has been certified and given to the public guardian, who then becomes their statutory guardian, right? Perhaps not to that point, but it's acknowledged by the health authorities and doctors and hospitals that the person isn't capable of making their own personal care decisions. Then it's true that the parents do function as their substitute decision maker, which is a statutory capacity. People don't always get the weight that they need to get information, informed consent, informed information for consent. But technically, you could try to rely upon being a substitute decision maker. That's only for personal care. It's not property. Then the question comes into play, well, they're really not capable. Should I seek legal guardianship? Well, yes, you can. You can have the child assessed as to capacity. Now, of course, there's the question of, can you get them to sit still to be assessed? That's just a practical issue. Sometimes you can't, that's it. But if you're able to have them assessed, then you could seek legal guardianship with the court. And what this does, this does in fact take away from the child, from the person, the power to make their own decisions. The parents become typically the legal guardians, and then they have full access because they then stand in the shoes of the child who's not capable. And when I say child, I mean adult. So we often have this discussion about the balance between powers of attorney, substitute decision makers, and legal guardians. And we don't normally get into the discussion, although we raise the point because we're obliged to. But if the child is found by the medical parties involved to be not competent, for some reason, they're found to be not competent as to property. When the real issue with the doctors and hospitals is the personal care. But they're found not competent as to property, which is true. And then this certification is given to the public guardian and trustee, at which point the public guardian becomes their statutory guardian of property, but not person, typically. It is, let's just say, sort of remotely possible, technically, legally possible. The public guardian does not generally become the statutory guardian of person. Now, listen, if you have, if anything to contribute towards that, that'd be fine. But it's always escaped me why doctors find that people not competent as to property when the issue here is personal care. Now, personal care is a lesser test than property. Personal care, and there's a sort of a scale, in a sense. A person doesn't just have a single set test for competence, and either you are or you aren't. That's it. It's a matter of cognitive ability, cognitive capacity, mental capacity, and complexity. And if you're up to the question, whatever that question is, well, then you're competent. But if mentally you're not competent, not up to the complexity of the issue, if you perhaps understand but don't appreciate, well, then you're not competent as to that item, that particular thing. So, for example, you can be competent to marry, but not competent to divorce, because, of course, there's perhaps more complexities in divorcing, division of assets, and all those things, spousal support, child support, all those things. There's perhaps more complexity in divorcing than there is in getting married. So that's an issue. The powers of attorney for property, they would allow the parents to manage things like ODSP payments and benefits, applications for the disability tax credit. Otherwise, the doctor won't cooperate with you, of course. Management of the RDSP, those kinds of practical things. And these documents are only alive while the person is alive. But when the person dies, the documents die. This is the Ulysses clause contract. And you may recall the Ulysses, Iliad and Odyssey, Troy story 1 and 2. And Ulysses was returning from the Trojan War, and he wants to sail past the sirens, who sing so sweetly that they entice sailors into the sea where they drown them. So what he does is he has his sailors tie him to the mast so he can't jump into the sea. And then they put wax in the ears of the rowers, the sailors. So what the Ulysses clause does is it allows a person who happens to have periods of insight into their illness to prepare powers of attorney for personal care, not property, which allows the persons appointed by them to enforce compliance with care. And to make a long story short, you have to show that the person is competent first with capacity assessments to enter into the power of attorney. And then once it's been signed within a certain period thereafter, that they still knowingly consent to what they did. But it's an interesting alternative, which, if there was the right fact situation with periods of insight, periods of illness, then you could use a power of attorney for personal care with the Ulysses clause to give an enduring right to, for example, the parents to help to manage health care for their child. You'll get all of these slides. Everyone will get these slides. So you have to have capacity assessments confirming capacity. It's a very interesting process. This is just about substitute decision makers. It's more applicable quite often when there's just nothing else you can do. And you want access to medical records. We have a substitute decision maker package, a bundle, and it has affidavits and proof of birth and proof of parentage and sections of the act and so on. But it also has my cover letter with my letterhead. And about halfway down in bold, it says informed consent. And of course, doctors and hospitals are aware that there's supposed to be informed consent to treatment. And of course, when this is typed up on legal letterhead, it tends to get a bit more attention. Something adds a bit of weight, but it doesn't really take the place of legal guardianship if that's otherwise appropriate. And the substitute decision maker capacity really is only in place if the person is not capable. Here's guardianship. It's a process, it's a court application. There's legal fees, there's 2 capacity assessments. We did a whole webcast on this about a month ago. It takes a few months. You have to have the involvement of the public guardian, but they're happy to be involved. Often they're quite kind enough to waive their fees, have minor fees involved. And what happens is a person, the parents, sometimes along with a sibling or an aunt or an uncle, is appointed by the court as the legal guardian, which precludes the public guardian becoming the the statutory guardian, and taking priority, in fact, over the parents. If there's no pre-existing power of attorney for personal care. If you have a pre-existing power of attorney for personal or property, and then the person becomes not competent, then they can't revoke the pre-existing powers of attorney. So this is good. But the legal guardianship is something that is a very powerful step. We've had situations, just to comment, where the person with the mental illness, years and years go by, decades go by. Sometime years before they were found not competent, they became the ward of the public guardian, who then manages their ODSP and whatever else, but not personal care very much. And we've had them released from the public guardian, because if you then have someone assessed again as to capacity and they're found competent, then they can be released from the statutory guardian. And there are, thankfully, situations, for example, where someone has perhaps a bipolar disorder, and by the time they're in their mid-50s, they've been through rounds of treatment, different medications, things have stabilized. They're nice people, quirky perhaps, but nice people. And you can get them released from the statutory guardian. Just looking at the questions here for a second. Here's an interesting one, of course. If we are lucky enough to find respite services, how can we get the child, the adult, to go there if he doesn't want to? Pretty darn difficult. I remember a mother up in Sudbury, and her husband was deceased, no other children. And she had set up an apartment for her son who had schizophrenia. And the apartment was, reasonably affordable at that time, some years ago now. And she would go there basically daily, cook his food, clean up, make his bed, the whole thing. Pretty sweet for him, eh? And she was very tired. She's getting old. So she was able to find a shared, more group situation for him. So she tried to convince him to try it out. And he did go and try it out. But of course, he stayed there for about a day or two and left and went back to the apartment. Because of course, there's nothing in it for him, right? At the group home, he's got to help with the dishes and help with the supper and make his own bed. And like, he's got a pretty sweet thing going with his mom. And it's not stupid. So it really just depends on the child, the adult child. It's all interesting as well because when the parents pass on, of course, their siblings often really have had enough of this for decades. But if they're still around and if they're still prepared to be involved, then sometimes the siblings, and sometimes it's helpful if there's 3 of them, because then clearly they can outvote, outnumber, outweigh the one child who's been catered all her life. And now the parents are deceased. And they can exercise some tough love. No, you can't stay in the family home. No, it's too big for you. No, we can't afford this. Because, you know, people can be unrealistic as to expectations. Oh, well, you should buy me a new home. This kind of thing. So just what it would be that would motivate the child to go to the other living situation. It's a very interesting discussion.
Often our experience is when families pass away and siblings now take charge, is they're often very caring and can be an incredible support to their loved one who has struggled for many years with mental illness. And we often provide support to those siblings in terms of helping their loved ones, their ill sibling. And again, I would encourage people, if you're in that situation where you're now put in a position of caring for your sibling who has a mental illness, to connect with a support program as to help guide you in terms of how to be helpful to them. Sorry to interrupt, but I just...
No, go ahead. That's great. Our son lives in a private apartment in our home. Does that mean that we cannot be named in a personal care power of attorney as he pays us rent for that apartment? We have a financial power of attorney for ODSP purposes. For ODSP, it could be that that ODSP, for their own purposes, have agreed that you can be the ODSP trustee. But if you do have a signed power of attorney for property, that's great. As far as personal care, the fact that the child lives in a unit that you've set up and pays you rent, quote unquote, actually that rent, quote unquote, should not be included as rental income. And Jack, I think I've told you this before, so I'm sure you know. And as far as the powers of attorney for personal care, there's no conflict at all with the fact that you are both a, quote, landlord and also the having power of attorney for personal care, not an issue. Another question. We have a nonverbal autistic 20-year-old daughter with developmentally at 2-year-old level. She can't sign for herself, doesn't understand simple instructions. She has mental illness and can be violent at times. We don't have legal power of attorney for personal care yet. 20 years, okay. Do you think we will run into problems in the future? Well, it doesn't sound to me like she's competent to sign the powers of attorney. And my experience is that we should discuss guardianship. And it may be, my experience is that you, the parents, may well get cooperation from medical authorities, doctors, hospitals. The question that comes up is, are you, in practice, getting that cooperation, that support? If you are, for now, that's great, right? If you're not, well, okay, that's in discussion. Let's talk about that. But then what happens when you're gone? Because if the child is clearly not competent, third parties are not going to pretend that she is. And what you'd want to consider is you having legal guardianship, or you arranging legal guardianship while alive, perhaps not primarily for yourself, maybe because you're presently getting cooperation. But what about whoever it is, their siblings, for example, cousins maybe, who are kind enough to be prepared to be legal guardians when you're gone. Because of course you'll need somebody who would not fit into even the substitute decision maker tree, and who clearly has standing to help assist the child, and who can handle the registered disability savings plan, which by that time is $300,000. So these are the transitional questions, like what happens when mom and dad are gone, which of course is what we, you know, one of our primary issues. Is there an inventory of family support systems or resources in Ontario? As we have found very little locally. I'm not aware of a resource system like that. Alison?
No, I'm actually, it's a real hole in the mental health care system, a real gap.
Yeah.
That there aren't. But I would suggest calling either 211 and asking to be connected, calling the Schizophrenia Society or the Mood Disorder Association or Canadian Mental Health Association, and they should be able to guide you.
That's true. Are there any options for someone with a mental illness who is reckless with money? Well, that's a whole lot of people who don't have mental illnesses. But if you're a person with a mental illness who is reckless with money, you have to look at issues, ways to manage, micromanage, give the child $50 a week, $10 a day, those kinds of things. But it's a real ongoing issue. And
sometimes it can be one of the symptoms of somebody who has a bipolar illness and in a manic state.
That's true, eh?
Might not be able to manage their money, and so it would be a good discussion to maybe have with their doctor or whoever else is helping that individual in terms of what would be best to protect them from dangerous spending while they're in an ill state. Yeah,
and manipulation by others.
Yeah, and they might be vulnerable to manipulation by others, absolutely.
Acquiring friends. Yeah, absolutely. There's a question here from Wendy. I have a basement apartment in my home. My son lives there, pays me rent. Did you say that I don't have to claim the rent on my income tax? Yes, that's the answer. If you have any questions or you'd like a memo on that, contact Karen at my office, karen@kpopelaw.ca, or extension 100, and she'll send you the memo. This is an excellent question from Stephanie. With a Henson Trust as an only sibling, acting as trustee, how do I maintain an arm's length financial management role while fostering a loving relationship? Is it better to have a third party appointed as the trust holder, the trustee? That's an excellent question. And yes, it could well be that in order to maintain the sibling relationship, it's best not to be trustee, because then you're also holding the purse strings and you're getting the phone calls at 11:30 at night, or your wife is getting them because you already gave your brother money to fix the car and he spent it on something else and now he wants it again. So yes, and you could have a trust company or a trust company with you, but the trust company holds the purse strings. So that's certainly worth considering. It is my understanding regarding power of attorney for personal care that the attorney can only make decisions once the person is mentally incapable, no, and can be challenged by the person who was given the power of attorney, yes. As to their incapacity, incapacity is not the issue. Although if a person is found to be incapable after the powers of attorney are granted, well, then they can't be changed or challenged if the person has been found to be incapable. Is that true of property power of attorney as well? Yes. We're going to try to wrap up here. Alison, if you think of any closing remarks and comments you'd like to make too. I'll just touch briefly on this. We have clients who have sizable RRSPs or RIFs. And if their child, and this is sometimes an open discussion, if they have a child who's cognitively impaired, and is a mental illness a cognitive impairment, then it's possible for you to set up a lifetime benefit trust to roll over your RIF, your surviving parent, rolling over their RIF for $500,000 or $1 million, whatever it may be, to the lifetime benefit trust. And the payments from the RIF are made to the trust. The income is attributed to the child, and this is very tax advantageous. But the trust receives the money, and the trust administers the money and uses it for the child's benefit. So what happens is, instead of dying with $500,000 RIFs and paying $250 to the government in taxes, you don't pay $250, and you roll it over to the lifetime benefit trust. And I won't go into a lot more detail, but basically the money is paid out over the lifetime of the child, taxed in the hands of the child at either a negligible rate or a much reduced rate. Those are just the calculations.
Ken, there's just one question from Connie. She
Yes.
wants to know, does she need a power of attorney to set up a trust fund?
No, the trust fund flows from a death. It flows from a will. It's a trust arrangement in a will to receive an inheritance into a Henson Trust, or, for example, into a lifetime benefit trust if it's registered funds. And no, the trustee is appointed, named in the will, has nothing to do with powers of attorney. Final question here about the disability credit. I've been helping my relative with a mental illness with meals for years. So you've been helping him with food, necessity. And he recently received the disability credit going back 5 years. What does Revenue Canada need for documentation for us to claim the DTC since he does not have income? Well, you're right. He qualifies for it, but he can't use it because he doesn't pay taxes. So it could be transferred to you if you are a relative, and if you've helped with necessities, food, shelter, clothing, to some extent, and it appears you've helped with food. And so it's transferred to you if you pay tax and backfiled, and it reduces your taxes by about $1,600 a year. So there's $8,000, that's good for you, and no more than you deserve. And then going forward, it saves you about $1,600 a year as well. You should also then consider the caregiver tax credit. I won't go into this in detail, but there's a second credit. The disability credit has to be approved for your relative to be approved for this. And then there's the requirement to transfer it to you. You have to help with the necessities and so on. But the caregiver credit, a short story, is if you're able to put the disability credit transfer into place, then you can certainly use the caregiver credit. And for the last 2 years, 2017, 2018, the person doesn't have to live with you. If they did live with you prior to that, then you can go back up to a total of 10 years and recapture the caregiver for those previous years too. And you recapture about $7,000. And going forward, it saves you about $1,000 a year. If you have questions about that, send some email to crystal@kpopelaw.ca or extension 101. Okay, so there's 86 participants, Bill. That's pretty good. Is there any documentation needed? The meals were provided? No. You just simply have to state the truth on the forms. If you're telling the truth, it's true. Alison, did you have any last comments?
I just wanted to, say that I know how hard it is for families when you support your family member who has a mental illness, emotionally, financially, physically. I would encourage people, and I think I've sort of belabored this, but to reach out and get support. Call your local mental health facility, your local hospital, the social workers or the psychiatry department, and find out where you can get support for yourself, because it's what our families often find most helpful is being in groups with other family members who are struggling with similar kinds of difficulties, and learning from each other and knowing that they're not alone with it, because it is a challenge, and we know how much you love your loved one, and sometimes loving them can be how can I word it, very very draining in terms of being able to be helpful at the same time as being loving.
Very difficult, yes. Very difficult. And that's what makes our work so rewarding. You're dealing with phenomenal people, phenomenal families, who just put one foot in front of the other and do what has to be done for their child all of their lives. And then at the end of the day, their main concern is, well, what will happen to my child when I'm gone? And, technically then that brings us into, discussions about Henson Trusts and so on. But, the peace of mind that we try to bring to people is delivered in different ways, different legal techniques. But the real issue is, what will happen to my child when I'm gone? And I remember one mom said, I just want to live one day longer than my daughter. Occasionally, I suppose it might happen. But it's a long haul. The families we work with have nothing but the greatest respect, as far as I'm concerned.
Absolutely, I would concur completely. Yeah.
Okay, well, I think that's a good wrap-up point. I'll stop, Karen. I'll stop sharing here.
Just one thing, Ken.
I'm oversharing, I guess.
No, just one thing, Ken. Does everybody get the slides sent to them? Just somebody said that you skipped over the Henson Fund slide, and that was one of her reasons for the webinar.
I'm sorry, say that again.
So I have a client here said you skipped over the Henson, she wrote fund, I think it's trust slide. Can you please review? That was the reason for us being on this webinar.
Okay, well then I'll briefly do that. That's this slide here. And in your will, there's a trust arrangement to receive the share of an inheritance or life insurance or anything else that you may wish to leave for that child. And the trust provisions in the will don't kick in until you pass on, or the survivor of the parents typically, although there's variations and other things we can do. But typically upon the second death, the estate is divided. Sometimes it's equal, most of the time it's equal. Other times it's disproportionate. And the trust arrangement in the will, nothing kicks in until you die. There's no administration, there's no charges, there's no tax filings, there's nothing to be done. That's a very common misconception. And this trust has trustees appointed who then file tax returns and excuse me, disperse money for the child, the beneficiary. There's no limitations to how much can be in that trust. It could be millions of dollars if you wish. More power to you. There's no limit on disbursements. And And then one day the child passes on decades later, and the trust determines where that child's share goes, typically to the siblings, sometimes to the grandchildren, sometimes to charity, and that's how that works. Sorry about that, I skipped over that. Okay, so shall I stop sharing?
Yeah, do you mind if I say one thing? Anybody whose questions I haven't answered, if they want to email me at karen@kpopelaw.ca, I will answer any questions I can get to.
Okay, thanks, Karen. Okay, thanks.